Judge Harrison's smirk vanished as 10-year-old Marcus Johnson calmly cited Reynolds v. Westfield Medical Center 2018, the judge's own ruling from 3 years prior. The courtroom fell silent. No one had expected this child, whom the judge had mockingly called the little lawyer, to deliver the precedent that would save his mother's career and change their community forever. Before we dive into this incredible story of justice and courage, I'd love to know where you're watching from. Drop your location in the comments, and if you believe in standing up against discrimination, hit that like button and subscribe to our channel. This remarkable journey of a brilliant young boy outsmarting a biased system is one you won't want to miss. So let's rewind and discover how Marcus Johnson became an unexpected legal champion for his mother against all odds. Eleanor Johnson had never imagined her life would depend on the legal brilliance of her 10-year-old son. At 38, she had built a respectable career as a registered nurse at Clearwater Memorial Hospital, known throughout Riverside County for her meticulous attention to patient needs and her compassionate approach to healthcare. 15 years at the same institution had earned her a reputation for excellence, particularly among underserved patients who often felt overlooked in the healthcare system. Her colleagues respected her clinical skills, while patients frequently requested her by name, appreciating her ability to explain complex medical concepts in understandable terms and her unwavering advocacy for their needs. This professional success had been hard-won, balanced against the personal challenges of raising her son Marcus alone after her husband David's death from aggressive pancreatic cancer 5 years earlier. Their modest two-bedroom home in Oakwood Heights, a predominantly black neighborhood on the east side of town, wasn't fancy, but was always filled with books, music, and the warm conversations between mother and son that had sustained them through their grief. The walls displayed both David's law school diplomas — he had been a public defender until his illness — and Marcus's numerous academic achievement certificates that had begun accumulating since preschool. Marcus had shown extraordinary intelligence from his earliest years, reading fluently at 3, solving complex mathematical equations by 5, and displaying an uncanny memory for details that initially delighted and eventually astonished his teachers. While other children his age were reading picture books, Marcus had gravitated toward his late father's legal textbooks, fascinated by the systematic logic of law and the stories of justice hidden within dry case citations. David had nurtured this interest before his death, explaining basic legal concepts during bedtime stories and answering his son's increasingly sophisticated questions with patience and respect. After David's passing, Marcus had continued expanding his unusual legal library, scouring thrift stores and library sales for discarded law books, studying them with an intensity that sometimes concerned Eleanor. "Most kids collect comic books or baseball cards," she often teased him gently. "My son collects legal precedents and memorizes civil procedure." Though she supported his interests, Eleanor worried about him fitting in with peers. Marcus's advanced intellect had led to him skipping 2 grades, placing him in 7th grade classrooms at just 10 years old. While his academic achievements were remarkable, the social challenges were significant. Older classmates bullied him for his small stature and precocious vocabulary. Teachers sometimes found his questions challenging rather than engaging, and he had few close friends who could relate to his unusual interests. Eleanor had created weekend traditions to ensure they maintained a close bond despite her demanding nursing schedule. Saturday mornings meant homemade pancakes shaped like scales of justice, Marcus's request, while discussing the week's events. Sunday evenings were reserved for documentaries on historical legal cases or social justice movements, followed by animated discussions, where Marcus often surprised her with insights that seemed impossible for his age. Balancing her work responsibilities with Marcus's school activities required careful planning and sometimes impossible choices. Eleanor had missed some of his academic competitions due to hospital staffing shortages, while occasionally using precious sick days to attend his school events. The guilt of these trade-offs was a constant companion, though Marcus seemed to understand the necessities of their situation with a maturity beyond his years. Eleanor's recent promotion to nursing supervisor had brought both professional validation and new challenges. The position represented significant achievement as one of the few black nurses in leadership at Clearwater Memorial, a prestigious hospital serving a predominantly wealthy white community. The promotion had come with increased responsibility and better pay, but also with subtle changes in how some colleagues interacted with her. Exclusion from certain meetings, higher scrutiny of her decisions, and coded comments about her different perspective had become more frequent. Marcus, with his keen sensitivity to injustice, had noticed these changes in his mother's demeanor after work, asking careful questions about her day that revealed his growing awareness of racial dynamics in her workplace. "You seem tired in a different way lately, Mom," he had observed one evening. "Is it the job or the people?" His perceptiveness had prompted honest conversations about workplace discrimination and the additional burdens faced by people of color in professional settings. Unknown to Eleanor, these discussions had inspired Marcus to secretly study her employee handbook and hospital policies, downloading them from her laptop to his tablet and analyzing them with the same intensity he applied to legal textbooks. He had begun maintaining a folder of notes titled Mom's Work Rights, methodically documenting relevant employment laws and hospital regulations. This background knowledge would prove crucial when Eleanor made a discovery that would ultimately upend both their lives and expose the systemic discrimination embedded within Clearwater Memorial's prestigious facade. The morning everything changed had begun like any other Eleanor reviewing patient charts over breakfast, while Marcus quizzed himself on legal terminology, neither of them aware that her routine administrative work was about to uncover disturbing patterns of racial discrimination in patient care that would set them on a collision course with the hospital administration, the powerful Harrison family, and eventually the judicial system where Marcus's extraordinary legal mind would face its greatest test. The morning Eleanor discovered the disturbing pattern began with her routine review of patient care metrics, a responsibility she took seriously as part of her nursing supervisor role at Clearwater Memorial Hospital. The hospital's pristine halls, state-of-the-art equipment, and sweeping views of the riverside skyline reflected its status as the premier medical facility serving the county's wealthiest residents. Eleanor had developed a meticulous documentation system for tracking various aspects of patient care across her medical surgical floor, believing that consistent data collection was essential for maintaining high standards and essential for identifying areas for improvement. While examining pain management protocols across different patient demographics, a project she'd initiated to ensure consistent care standards, she noticed what seemed to be a subtle but concerning pattern. Black and Hispanic patients appeared to be receiving lower doses of pain medication than white patients with identical conditions and pain scores. Initially assuming she was seeing a coincidence or statistical anomaly, Eleanor expanded her review to include more cases, methodically organizing the data by diagnosis, reported pain levels, prescribed medication dosages, and patient demographics. As the sample size grew, so did the disturbing consistency of the disparity. Patients of color were consistently receiving approximately 20% less pain medication than their white counterparts for identical conditions, even when controlling for weight, age, and other medical factors. Troubled by her findings, but determined to be thorough before raising concerns, Eleanor spent 3 additional weekends reviewing 6 months of patient records, creating detailed spreadsheets that displayed the patterns with undeniable statistical significance. She consulted quietly with Dr. Arjun Patel, an anesthesiologist colleague whose expertise in pain management and statistical analysis she trusted. "This isn't random variation, Eleanor," he confirmed after examining her data. "The pattern is consistent across providers and too significant to be coincidental. You need to report this." Though anxious about the potential repercussions, Eleanor arranged a meeting with Dr. William Griffith, the hospital's chief medical officer, a distinguished-looking white man in his 60s who had been with Clearwater Memorial for nearly 3 decades. She presented her findings professionally, focusing on the data rather than accusations, and suggested a systematic review of pain management protocols to address the disparities. Dr. Griffith's response was immediately dismissive. "These things look like patterns when they're just coincidences," he said, barely glancing at her meticulously prepared materials. "Are you sure you're not being—" Oversensitive pain management is subjective after all. His patronizing tone and quick dismissal of evidence that had taken weeks to compile only strengthened Eleanor's resolve. "With respect, Dr. Griffith, this analysis controls for that subjectivity by focusing on patients with identical pain scores and diagnoses. The disparity remains consistent. Across hundreds of cases," she insisted, requesting a formal investigation into the patterns she had identified. The meeting ended with Griffith's vague promise to look into it, but the atmosphere at work changed noticeably afterward. Previously friendly colleagues became distant. Her input in meetings was increasingly interrupted or ignored, and she found herself excluded from important discussions about department policies. The most disturbing development came a week later when she discovered an anonymous note in her locker. Some people should know their place. Rather than intimidating her, the threat reinforced her conviction that she had uncovered something significant. Eleanor began documenting every interaction related to her report, saving emails, recording meetings when legally permitted, and keeping detailed notes of conversations. She reached out to the hospital's diversity committee, finding an ally in Dr. Sofia Rodriguez, who revealed that similar concerns had been raised previously, but somehow never resulted in formal investigations. "The complaints always disappear into administrative black holes," Dr. Rodriguez explained. "Your data is the most comprehensive evidence I've seen. Don't let them bury this." Together, they discovered records of at least 3 previous complaints about disparate treatment that had been classified as resolved without explanation or action. Eleanor's growing realization that exposing these discriminatory patterns might cost her the career she had built over 15 years weighed heavily on her. One evening, finding Marcus studying a legal text on whistleblower protections, she recognized he had sensed her concerns. Their conversation that night would strengthen her resolve to continue pursuing justice despite the risks. "Sometimes doing the right thing isn't the easy thing, but that doesn't make it less right," she told him, echoing words his father had often used. "Dad would say the measure of our character is what we do when it costs us something." Marcus replied with a wisdom beyond his years. With Dr. Rodriguez's support, Eleanor escalated her complaint to the hospital board, preparing a comprehensive presentation that methodically demonstrated the patterns of disparate treatment across different departments. During the tense board meeting, she maintained professional composure while presenting irrefutable evidence of racial disparities in pain management. Board Chairman Richard Harrison, a tall, imposing man with silver hair and cold blue eyes, responded with barely concealed contempt. "Perhaps Nurse Johnson doesn't understand statistical analysis. Correlation is not causation after all." As she left the meeting, Eleanor overheard a conversation revealing that Board Chairman Harrison was the brother of Judge Thomas Harrison, a connection that explained the seemingly coordinated response to her complaint. The retaliation began almost immediately. Her schedule was repeatedly changed, with minimal notice, making childcare arrangements nearly impossible. Her patient assignments doubled while support staff was reduced, and she received sudden performance critiques, citing vague communication issues that had never been mentioned in 15 years of consistently positive evaluations. When Dr. Evelepper Griffith called her into his office to issue a final warning for allegedly creating a hostile work environment with unfounded accusations, Eleanor recognized the systematic effort to push her out. With her career and livelihood at stake, she made the difficult decision to file a formal discrimination and whistleblower complaint with the Equal Employment Opportunity Commission, knowing that this action would likely escalate the probable conflict, but seeing no alternative path to addressing the institutional discrimination she had uncovered. Eleanor arrived at work on a Tuesday morning in October to find her badge deactivated at the hospital's main entrance, the security guard avoiding eye contact, as he informed her that she needed to wait for a human resources representative. The momentary confusion gave way to a sickening realization as she spotted 2 additional security officers approaching from the lobby. She was being terminated. "Miss Prive Johnson, please come with us to collect your personal belongings," the HR representative stated flatly, loudly enough that several arriving nurses and a group of visitors turned to watch. The humiliating procession through the hospital corridors felt deliberately designed to maximize her embarrassment with security, flanking her as if she were dangerous rather than a dedicated employee of 15 years. Staff members stopped mid-conversation to stare, as she passed, some with sympathy in their eyes, others with vindication, but none intervening in what was clearly a power display meant to warn others against following her example. Dr. Griffith was waiting in her small office, holding a white envelope and wearing an expression of professional regret that didn't reach his eyes. "Eleanor, we're terminating your employment effective immediately," he announced without preamble. This letter outlines the policy violations and unprofessional conduct that necessitated this action. Hospital security will escort you off the premises once you've collected your personal items. His clinical delivery of words that shattered her career and financial security seemed designed to provoke an emotional response that would justify their treatment of her. But Eleanor maintained her dignity, methodically packing her few personal belongings. Family photos, a nursing award her spare scrubs, while feeling dozens of eyes watching through the office's glass walls. Have you ever witnessed someone facing blatant injustice with dignity and strength? Comment number 1. If you've experienced or observed workplace retaliation for speaking truth to power. Or number 2, if you believe more protections are needed for whistleblowers who expose discrimination. Don't forget to like this video if you admire Eleanor's courage and subscribe to our channel for more stories of ordinary people fighting extraordinary battles against systemic injustice. How would you react if your livelihood was suddenly taken away for doing the right thing? And what lengths would you go to protect your child while fighting for justice? The moment the automatic doors closed behind her, Eleanor reached her car. Just as her composure crumbled, a panic attack, overwhelming her in the isolation of the parking garage. The implications crashed down like physical blows: their mortgage payment, due in 2 weeks, Marcus's school expenses, health insurance suddenly terminated, and the devastating prospect of explaining to her son why the institution she had served faithfully had discarded her for exposing discrimination. The drive home became a blur of tears and desperate calculations, her mind racing through scenarios for finding new employment while mentally rehearsing how to tell Marcus. Unbeknownst to Eleanor, Marcus had arrived home early from school due to a teacher development afternoon and discovered the termination letter on the kitchen counter while she was taking a shower to wash away the tears and gather her thoughts. His unusual legal knowledge allowed him to decode the corporate jargon and legal terminology in the document, recognizing the retaliatory nature of the firing disguised beneath accusations of creating a hostile work environment and making unfounded allegations against the institution. When Eleanor emerged from the bathroom, she found her 10-year-old son surrounded by legal notepads, already making detailed notes on wrongful termination statutes. Their emotional conversation that evening cemented their partnership in facing this challenge together. "They can't fire you for telling the truth, Mom. That's retaliation, and it's illegal," Marcus stated with absolute certainty, his small hands gripping a highlighter as he marked relevant sections of employment law articles he'd printed from the internet. The law is supposed to protect whistleblowers who report discrimination or safety issues. The reality of their situation quickly became apparent as Eleanor's calls to other hospitals in the region were met with sudden position freezes or vague promises to keep her resume on file. Former colleagues called discreetly to warn her that Clearwater administrators had been contacting other healthcare facilities, labeling her a problem employee who made unfounded accusations. With only 3 months of savings and their mortgage payment looming, the financial pressure mounted daily. Marcus's school called with concerns about his falling grades and distracted behavior, unaware of the crisis unfolding at home that kept him researching legal precedents into the early morning hours, instead of completing his precedents and behavior. Homework. Eleanor eventually accepted a night shift position at Sunshine Acres, a chronically understaffed nursing home on the outskirts of town that paid barely half her previous salary and offered none of the professional respect or advancement opportunities she had earned at Clearwater. The physical demands of lifting patients without adequate assistance, and the emotional toll of knowing her career had been derailed, left her exhausted and demoralized. Often arriving home, as Marcus was preparing for school, the two of them passing like ships in the night. One evening, Marcus overheard his mother crying in her bedroom, the muffled sobs reinforcing his determination to find a legal solution to their situation. The following day, he visited the public library after school requesting legal resources on employment discrimination and whistleblower protection that confused the librarian until she realized the intensity and focus with which this child approached his unusual research. "Are you working on a school project, young man?" she asked, helping him navigate the legal databases. "No, ma'am. I'm helping my mother with a wrongful termination case," he replied with such seriousness that she didn't question him further. During his third visit to the law section, Marcus encountered Gladys Turner, a retired paralegal who noticed his unusual selection of materials: employment law casebooks, whistleblower protection statutes, and civil procedure guides. "That's some heavy reading for someone your age," she commented, watching him methodically take notes with color-coded highlighters. Their conversation revealed Marcus's remarkable understanding of legal concepts and his determination to help his mother, impressing Miss Turner enough that she offered to become his informal legal mentor, meeting him at the library twice weekly to guide his research and answer questions about procedural aspects of employment cases. Eleanor's already precarious situation deteriorated further when she received a certified letter from Clearwater Memorial's attorneys threatening a countersuit for defamation if she pursued her EEOC complaint, the legal language, clearly designed to intimidate her into silence. When Marcus found his mother staring blankly at the letter, her hands trembling, he made a decision that would change the trajectory of their case. "Mom, we need professional help. There's a small legal aid clinic downtown that takes whistleblower cases. I found them while researching," he explained, showing her the notes he'd compiled on the Riverside Community Justice Center, a non-profit legal organization that specialized in employment discrimination. Their initial meeting with attorney Lisa Chen, a dedicated young lawyer who had rejected corporate offers to pursue public interest law, marked a turning point in their journey. Chen was initially skeptical about the case until she reviewed Eleanor's meticulous documentation of both the patient care disparities and the retaliatory actions following her report. "You've built the foundation for a strong whistleblower retaliation case, Miss Johnson," Chen acknowledged, impressed by the organized evidence. "The statistical analysis of pain medication disparities is particularly compelling, and your documentation of the timeline between your report and termination establishes a clear causal connection." With Chen's guidance, they filed a lawsuit against Clearwater Memorial for wrongful termination under whistleblower protection statutes, alleging both retaliation and racial discrimination. The notification that Judge Thomas Harrison had been assigned to their case sent a chill through Eleanor, who immediately recognized the name of the board chairman's brother, understanding that their fight for justice had just become significantly more challenging. As they prepared for the preliminary hearing, Eleanor could never have imagined that her greatest asset in this seemingly impossible battle would be her 10-year-old son, whose extraordinary legal mind was about to face its greatest test in a courtroom presided over by a judge who had already decided against them before hearing a single argument. Marcus Johnson's earliest memories weren't of toys or cartoons, but of his father explaining the concept of fairness with simple household objects. "If I give you 3 cookies, and your cousin one is," that fair David Johnson would ask his 3-year-old son. "Only if I did something to earn 2 extra cookies," little Marcus would reply, already grasping the fundamental principle of proportional justice that would fascinate him throughout his childhood. While other parents read fairy tales at bedtime, David shared age-appropriate stories about historical justice figures, Thurgood Marshall, Ruth Bader Ginsburg, Bryan Stevenson, presenting them as real-life superheroes who fought with words and laws instead of capes and special powers. The pivotal moment in Marcus's intellectual development came on his 4th birthday when his father gave him a children's book about Thurgood Marshall's journey, from a young boy denied access to his local library due to segregation to the lawyer who successfully argued Brown versus Board of Education. Something about the transformation of injustice through structured legal arguments captivated Marcus's young mind, and he began asking increasingly sophisticated questions about how laws worked. After his father's death, Marcus had found solace in David's modest collection of law books, treating them as both an intellectual connection to his father and a framework for understanding a world that suddenly seemed chaotic and unfair. While his mother worried about his immersion in such adult material, she recognized the healing it seemed to provide and supported his unusual interest by helping him build a small legal library from thrift shops and library sales. Marcus approached legal concepts with the same methodical attention other children devoted to video games, creating intricate systems for organizing and memorizing information. His bedroom closet had been converted into a makeshift law office with milk crates filled with color-coded file folders, legal pads covered in his careful handwriting, and walls papered with flowcharts of legal procedures he'd created to visualize complex processes. He memorized legal precedents with the same ease other kids, memorized sports statistics, often reciting case citations and key findings while shooting baskets in their small backyard. His comprehensive knowledge of state and federal whistleblower protection laws had developed gradually over years of reading, beginning with his father's books on employment law and expanding through internet research and his growing collection of legal textbooks. This background proved invaluable when his mother faced termination, as he already understood the basic framework of protected activities and retaliatory actions. Miss Turner, the retired paralegal who became his mentor after their chance meeting at the public library, quickly recognized Marcus's extraordinary legal reasoning abilities. "You don't just memorize the rules, which is impressive enough," she told him during one of their study sessions. "You understand the principles behind them and can apply them to new situations. That's how seasoned attorneys think." His first practical application of legal knowledge had come the previous year when his classmate Darius faced suspension for allegedly damaging school property. Convinced of his friend's innocence, Marcus had researched the school's disciplinary procedures and found that administrators had violated several of their own policies in rushing to judgment. According to Section 4.3 of the Student Handbook, Darius is entitled to examine any evidence against him before a disciplinary hearing. Marcus had informed the astonished principal proceeding to cite 5 specific procedural violations in the handling of the case. The security footage subsequently revealed another student committing the vandalism, vindicating Darius and establishing Marcus's reputation among peers as someone who could help with unfair situations. Following this success, Marcus began keeping a detailed journal of legal principles and interesting cases he encountered in his reading, creating his own simplified legal encyclopedia that he continuously updated with new information. Eleanor had initially viewed her son's lawyer games with amusement, encouraging his intellectual development while gently steering him toward more age-appropriate activities. However, as she observed his growing facility with complex legal concepts and his genuine passion for justice, her amusement gave way to a mix of pride and concern about the pressure he placed on himself to understand adult problems. His interest in healthcare law had intensified when Eleanor started at Clearwater, with Marcus asking detailed questions about patient rights and hospital policies that sometimes left her struggling for answers. Unknown to Eleanor, Marcus had created a secret folder on his tablet titled Healthcare Discrimination Cases, meticulously documenting legal precedents involving racial disparities in medical treatment from across the country. The folder had expanded significantly since his mother's termination, now including subcategories for whistleblower protections, retaliatory firing statutes, and burden of proof standards in discrimination cases. Attorney Chen's first indication of Marcus's unusual abilities came during their second case preparation meeting when he politely but confidently corrected her citation of a federal procedural rule. "Excuse me, Miss Chen, but I think you meant Federal Rule 26b-5 regarding privileged information, not 26b-4, which covers expert witnesses," he interjected, causing the attorney to stare in bewilderment. Marcus: How do you know the difference between Federal Rule 26b-4 and 26b-5? She asked, genuinely perplexed by this child's knowledge of civil procedure minutiae. I memorized the federal rules of civil procedure last summer, he explained matter-of-factly. The discovery rules are particularly interesting because they determine what information becomes available to each side. Despite her initial skepticism, Chen quickly recognized the value of Marcus's extraordinary knowledge and began incorporating his insights into their case strategy. His most significant contribution came when he discovered records of a similar case against Westridge Medical Center, another hospital owned by the same parent corporation as Clearwater. Buried in public records was a settlement agreement that directly contradicted Clearwater's defense claims about their pain management protocols, providing crucial evidence of corporate knowledge of disparities in patient treatment. As their preliminary hearing before Judge Harrison approached, Marcus undertook his most ambitious research project, yet a comprehensive analysis of the judge's previous rulings to identify patterns and preferences that might help them prepare effective arguments. He created hundreds of note cards organizing Harrison's judicial history by case-type ruling patterns and legal reasoning, looking for any advantage in what he recognized would be an uphill battle given the judge's connection to his crate. Clearwater Memorial's board chairman. He's ruled against employment discrimination plaintiffs in 19 of his last 20 cases, Marcus informed Chen and his mother one evening, spreading his analysis across their kitchen table. The statistics show a clear pattern of favoring employers, especially in cases involving minority plaintiffs. What most excited Marcus, however, was the single exception he had identified: Reynolds v. Westfield Medical Center, a case from 3 years earlier where Harrison had ruled in favor of a nurse whistleblower against a hospital. This case is different from his pattern, Marcus explained, pushing forward a thick folder of notes. He not only ruled for the plaintiff, but wrote a passionate opinion about whistleblower protections and the importance of statistical evidence in proving patterns of violations. Further research revealed a personal connection. The plaintiff, Rebecca Reynolds, was the daughter of Harrison's former law professor at Harvard, explaining the anomalous ruling in an otherwise consistent pattern of anti-plaintiff decisions. Most importantly, Marcus realized that the legal principle Harrison had established in that ruling, that statistical evidence alone could establish a pattern of violations sufficient to support a whistleblower claim, directly applied to Eleanor's situation. "Mom, this is exactly what we need," he exclaimed excitedly. "Judge Harrison can't contradict his own precedent without exposing his bias. If we can get him to acknowledge the Reynolds case, he'll have to apply the same standard to your evidence." Despite Marcus's enthusiasm, Attorney Chen remained skeptical about directly challenging Harrison with his own inconsistency. "Marcus, you're brilliant, and this research is impressive, but judges don't respond well to being cornered, especially not by arguments coming from a child," she cautioned. "We need to be strategic about how we present this precedent." Marcus's frustration grew as preliminary hearings went poorly for their side, with Harrison consistently ruling in favor of the hospital's motions and restricting the evidence they could present about racial disparities in patient care. The night before their crucial hearing on the hospital's motion to dismiss, which, if granted, would end their case entirely, Marcus made a decision that would dramatically alter not just the trajectory of their legal battle, but his own future as well. While his mother slept after another exhausting shift at the nursing home, he carefully compiled a comprehensive brief comparing the Reynolds case to his mother's situation, creating a point-by-point analysis that made the Reynolds 6, the 20.gob, parallels undeniable. Rather than trying to convince Attorney Chen to use his strategy, he placed the completed brief in her case folder, knowing she would find it during her final preparation in the morning. "Sometimes you have to create the justice you seek." He whispered to himself, a phrase his father had often repeated, never imagining that he would soon be putting this philosophy into practice in ways that would astonish a courtroom and change his family's future forever. Judge Thomas Harrison's imposing courtroom on the 3rd floor of the Riverside County Courthouse reflected his status in the legal community: dark mahogany paneling, soaring ceilings with ornate moldings, and a bench elevated significantly higher than standard, requiring attorneys and plaintiffs to literally look up to address him. His distinguished legal career had followed a predictable trajectory from Harvard Law School to a lucrative practice with a prestigious corporate defense firm before his political appointment to the bench 12 years earlier, a position he wielded with unwavering favor toward business interests and consistent skepticism toward discrimination claims. Legal observers had noted Harrison's pattern of dismissing employment discrimination cases at nearly 3 times the rate of his judicial colleagues, with particularly poor outcomes for minority plaintiffs challenging institutional practices. His courtroom procedures subtly reinforced the power imbalance between corporate defendants and individual plaintiffs, ruling quickly on objections from defense attorneys while requiring plaintiffs' counsel to provide extensive justification for similar objections, allowing corporate witnesses considerable latitude in testimony while strictly limiting plaintiff witnesses and frequently interrupting plaintiffs' attorneys mid-argument while corporate counsel spoke unimpeded. Eleanor and Marcus arrived for their first hearing in modest but carefully chosen attire. Eleanor in her only suit purchased years earlier for job interviews, and Marcus in dress pants and a button-down shirt that already showed signs of being outgrown. They sat quietly behind Attorney Chen at the plaintiff's table, acutely aware of the stark contrast between their solo legal representation and Clearwater's imposing team of 5 attorneys from Henderson, Wright & Patterson, the city's most expensive law firm. As Judge Harrison entered the courtroom, his tall frame draped in black robes, his gaze swept dismissively over Eleanor before settling with obvious recognition on Clearwater's lead counsel, James Patterson, with whom he exchanged the subtle nod of longtime acquaintances. Case number 2, 023CV 487. 2 Johnson v. Clearwater Memorial Hospital. Harrison announced, his deep voice resonating through the courtroom. This is a preliminary hearing on defendant's motion to exclude statistical evidence. Counselors, identify yourselves for the record. The contrasting introductions highlighted the resource disparity, Patterson introducing himself and 4 colleagues representing Clearwater, followed by Chen's solitary identification as counsel for Eleanor. Throughout the initial hearing, Harrison's bias manifested in subtle procedural advantages granted to the hospital's legal team, sustaining their objections without explanation, while requiring Chen to provide extensive justification for identical objections, allowing defense counsel to exceed time limits, while strictly enforcing them against Chen, and repeatedly interrupting her arguments with skeptical questions, while Patterson spoke uninterrupted. Counselor: these are serious allegations against a respected institution. Harrison admonished when Chen attempted to introduce Eleanor's statistical analysis of pain medication disparities. You'll need more than hearsay and subjective impressions to support such claims. His dismissive characterization of meticulously compiled data as hearsay revealed his predetermined position on the evidence's validity before even reviewing it. Marcus, sitting quietly beside his mother, began passing carefully written notes to Attorney Chen, identifying procedural irregularities and suggesting objections to Harrison's rulings. Rule 26. A1 requires them to have disclosed those reports. During initial disclosures, one note read, referring to documents, the hospital's attorneys suddenly introduced. Harrison noticed the interaction, his expression darkening, as he realized this child was actively participating in the legal strategy. "Young man, this is a courtroom, not a classroom," he stated sharply, interrupting Chen's argument. "Please refrain from passing notes to counsel." Marcus nodded respectfully, while continuing to write observations in his legal pad, his calm focus clearly irritating the judge. During the second preliminary hearing, Harrison became more openly hostile to their case, threatening outright dismissal while questioning Eleanor's motives and methods. These whistleblower claims require substantial evidence of actual wrongdoing, not merely personal grievances, he declared, despite not having reviewed the complete evidence package Chen had submitted. The court will not entertain vague accusations against a vital community institution without substantial proof of intentional discrimination. Harrison imposed arbitrary limitations on what evidence they could present, ruling that Eleanor's statistical analysis was anecdotal observations rather than scientific evidence, effectively gutting the core of their case before trial. Marcus noticed Richard Harrison, the hospital board chairman and judge's brother, watching from the gallery, occasionally exchanging knowing glances with the judge that confirmed their suspicions about the brothers' communication regarding the case. The tension reached its peak when Marcus, frustrated by a particularly egregious mischaracterization of evidence rules, quickly flipped through his legal reference book and whispered a citation to Chen. Harrison interrupted immediately. "Perhaps the little lawyer thinks he can try this case. This isn't a school debate, boy." The courtroom fell into uncomfortable silence at the condescending remark, with even some of the hospital's attorneys looking discomfited by the judge's mockery of a child. Chen quickly moved to protect Marcus from further targeting, apologizing for the interruption, while subtly positioning herself to block the judge's view of her young client. The devastating blow came at the conclusion of the third preliminary hearing, when Harrison granted the hospital's motion to exclude virtually all of Eleanor's documentary evidence of discrimination in patient care. Anecdotal observations do not constitute scientific evidence of discrimination, he ruled, despite the fact that Eleanor's analysis had been conducted using standard statistical methodologies and reviewed by a qualified physician. The plaintiff's subjective interpretations of routine medical decisions cannot form the basis of a whistleblower claim without clear evidence of intentional wrongdoing. Eleanor fought back tears as she recognized the systematic dismantling of their case through procedural rulings, each one closing off another avenue toward justice. Harrison concluded the hearing by scheduling a final hearing on Clearwater's motion to dismiss for the following week, giving them only 3 days to prepare their response. "Unless you can provide precedent that supports your position, that statistical evidence alone can establish a whistleblower claim, I'll be granting the motion to dismiss," Harrison stated with barely concealed satisfaction, rising to leave the bench. As the courtroom began to empty, Marcus leaned close to his mother, his expression showing not defeat but determination. "He just told us exactly how to beat him, Mom," he whispered with unexpected confidence. "He asked for precedent that supports statistical evidence establishing a whistleblower claim, and I know exactly where to find it." That evening, Marcus returned to the courthouse library, requesting access to complete records of Harrison's past rulings on whistleblower cases. The courthouse librarian, surprised to see a child researching judicial opinions, nevertheless helped him locate the materials, impressed by his serious demeanor and clear understanding of what he was seeking. As Marcus settled into his research, Harrison's judicial clerk noticed him surrounded by binders of the judge's past opinions and reported the unusual situation to Harrison. "There's a young boy in the law library, reviewing your past cases, sir. I believe he's the Johnson plaintiff's son." Harrison laughed dismissively, underestimating both Marcus's capabilities and determination. "Let him look. Maybe he'll learn something about real law," he remarked, unable to imagine that this child would uncover the very precedent that would undermine his carefully constructed barrier against Eleanor's claims and force a reckoning with his own judicial inconsistency. Marcus transformed the Johnson living room into a makeshift legal research center covering every available surface, with stacks of printed cases organized into precise categories: whistleblower rulings, employment discrimination cases, hospital liability decisions, and most importantly, Judge Harrison's complete judicial history on these topics. Eleanor watched with a mixture of amazement and concern as her 10-year-old son worked with the focused intensity of a seasoned attorney preparing for a career-defining case, sorting hundreds of pages of legal opinions into color-coded folders and developing an elaborate coding system to track patterns in Harrison's decisions. "Marcus, honey, it's nearly midnight," she said gently, placing a sandwich beside him that he hadn't noticed was his forgotten dinner. "You have school tomorrow." Without looking up from the spreadsheet where he was recording data points from each case, Marcus replied, "Mom, we have 3 days before they try to dismiss your case. Sleep can wait." His methodical approach to the research reflected an innate legal mind. He created a detailed tracking spreadsheet, identifying variables in each of Harrison's decisions: plaintiff demographics, case type, evidence standards applied, procedural rulings, and final outcomes, searching for patterns that might help them understand the judge's decision-making process. The emerging data painted a disturbing picture of judicial bias, revealing that Harrison had dismissed 97% of discrimination cases brought by minority plaintiffs compared to only 62% brought by white plaintiffs, a disparity too significant to be coincidental. Have you ever discovered evidence that completely changed your understanding of someone's character or actions? Comment number 1. If you've ever witnessed similar patterns of bias in systems that are supposed to be fair and impartial, or comment number 2. If you've had an experience where data and facts helped you overcome prejudice or discrimination. Don't forget to like this video if you're inspired by Marcus's determination to fight injustice through knowledge, and subscribe to our channel for more stories of ordinary people using extraordinary talents to challenge broken systems. What lengths would you go to in order to prove someone's inconsistency or hypocrisy when justice is at stake? And how can we ensure that our legal system truly provides equal treatment, regardless of race or social status? Amid the bleak statistics, one case stood out as a glaring anomaly: Reynolds v. Westfield Medical Center, where Harrison had not only ruled in favor of a nurse whistleblower, but had written an unusually passionate opinion defending the plaintiff's right to protection after reporting patient care concerns. "This is it, Mom," Marcus exclaimed, holding up the printed opinion like a prize. In every other case, he dismisses statistical evidence as insufficient or merely correlative. But in Reynolds, he specifically states that well-documented statistical patterns alone can establish sufficient grounds for a whistleblower claim to proceed to trial. Marcus launched into a deep-dive investigation of this aberrant case, retrieving every document from the court record and constructing a detailed timeline of the proceedings. The plaintiff, Rebecca Reynolds, was a white nurse who had reported patient safety violations at Westfield Medical Center, facing retaliation similar to Eleanor's experience. The case had numerous parallels to Eleanor's situation, yet Harrison had approached it with entirely different evidentiary standards and procedural rulings. The key breakthrough came at 2 a.m. when Marcus, bleary-eyed but persistent, discovered a newspaper article mentioning that Reynolds was the daughter of Professor William Reynolds, a longtime Harvard Law School faculty member. Further research confirmed that Professor Reynolds had taught constitutional law during Harrison's time at Harvard and was specifically thanked in the acknowledgments of Harrison's Student Law Review article. He ruled for her because of who her father was. Marcus realized the pieces finally connecting. The legal principle is sound, he just doesn't apply it consistently. The discovery energized Marcus to focus specifically on Harrison's Reynolds opinion, meticulously analyzing the legal reasoning and principles the judge had established. Harrison had written eloquently about whistleblowers as essential guardians of public safety whose statistical observations could constitute compelling evidence of institutional problems requiring judicial intervention. Most critically, Harrison had explicitly stated that statistical evidence showing consistent patterns of disparate treatment, even without smoking gun proof of intentional discrimination, creates sufficient factual questions to survive. Summary dismissal and proceed to trial. This precise legal principle established by Harrison himself directly contradicted his current position that Eleanor's statistical evidence was insufficient to support her claims. Marcus worked through the night, creating a comprehensive brief comparing the Reynolds case with Eleanor's situation, developing a point-by-point analysis, demonstrating the factual similarities. Both plaintiffs were nurses. Reporting patient care concerns. Both presented statistical evidence of problematic patterns. Both faced retaliation after making their reports, and both cases involved healthcare institutions with similar policies. The only significant differences were the plaintiffs' races and their connections to Judge Harrison. By dawn, Marcus had created a simplified visual presentation comparing the statistical evidence from both cases, demonstrating that Eleanor's documentation was actually more comprehensive and methodologically sound than the evidence Harrison had deemed sufficient in Reynolds. He carefully printed his completed analysis, organizing it into a professional-looking folder with tabbed sections and highlighted key points. An extraordinary work product that would have impressed associates at major law firms, let alone from a 10-year-old working with limited resources. When Attorney Chen arrived at their home the following morning to prepare for the dismissal hearing, she was astonished to find their living room transformed into a war room of legal research and Marcus ready to present his findings with the confidence of a seasoned litigator. "Did you really teach yourself the rules of evidence from a textbook?" she asked incredulously after reviewing his analysis. "The federal rules of evidence have clear internal logic once you understand the foundational principles," Marcus replied with characteristic seriousness. "The hearsay exceptions make perfect sense when you consider reliability factors." Chen's initial skepticism about using Harrison's own inconsistency against him gradually transformed into cautious enthusiasm as she recognized the strategic brilliance of Marcus's approach. "This is exactly the kind of precedent Harrison demanded," she acknowledged. "He can't easily distinguish these cases without exposing his bias." Together they refined the strategy, with Chen providing procedural expertise to structure the argument within proper legal frameworks, while incorporating Marcus's substantive research. Marcus helped Eleanor understand the legal concepts and potential outcomes, conducting practice sessions where he role-played Harrison's likely objections and coached her on maintaining composure if the judge became hostile. "What if this makes him even more biased against us?" Eleanor worried as they prepared her for potential questioning. "That's why we have appellate courts," Marcus explained with surprising sophistication. "If he ignores his own precedent, we'll have clear grounds for appeal. Either way, we create a record of his inconsistency." They anticipated Harrison might attempt to distinguish the Reynolds case from Eleanor's situation and prepared counter-arguments for each potential distinction, with Marcus developing detailed notes for Chen on cross-examination questions that would highlight the hospital administrators' contradictory statements about their pain management protocols. The night before the hearing, as Marcus made final adjustments to their presentation materials, Eleanor watched her son with a mixture of pride, amazement, and a touch of sadness that circumstances had forced him to shoulder such adult responsibilities. "No matter what happens tomorrow, Marcus, I'm so proud of who you are," she told him, pulling him into a tight hug. "Dad would be too." Marcus hugged her back fiercely, his small frame belying the strength of his determination. "We're going to win, Mom," he whispered with absolute conviction. "Judge Harrison already gave us the key, he just didn't realize it." As they prepared for bed, the carefully organized folders containing their legal strategy sat ready by the door, representing not just their case against Clearwater Memorial, but a 10-year-old's extraordinary stand against a blank system of power and privilege that had never expected to be challenged by someone like him. A challenge built entirely on the judge's own words, turned back upon themselves in service of true justice. The courtroom atmosphere crackled with tension as Eleanor, Marcus, and Attorney Chen took their seats at the plaintiff's table, facing what they all understood might be the final hearing of their case, if Judge Harrison granted Clearwater's motion to dismiss. Word of the unusual case involving a nurse's challenge against the powerful hospital had spread through the legal community, drawing a larger crowd of spectators than previous hearings, including several law students and attorneys with, quote, "no direct connection to the case but interested in Harrison's handling of employment discrimination claims." The hospital's legal team projected confident assurance as they arranged their materials, James Patterson occasionally glancing toward the plaintiff's table with barely concealed condescension, clearly expecting the swift dismissal Harrison had all but promised at the previous hearing. Harrison's entrance prompted the traditional all-rise announcement, his tall frame and imperious expression suggesting a man accustomed to unquestioned authority as he took his seat at the elevated bench. His brief glance toward the plaintiff's table registered surprise at the organized presentation materials and binders that hadn't been present at previous hearings. A momentary furrow crossing his brow before he composed his brow-compressed features into judicial detachment. "We're here on Defendant Clearwater Memorial Hospital's motion to dismiss Plaintiff Eleanor Johnson's whistleblower and wrongful termination claims," Harrison began looking expectantly toward the defense table. Mr. Patterson, you may proceed with your argument. Patterson rose smoothly, buttoning his expensive suit jacket with practiced ease. Thank you, Your Honor. As we've established in previous hearings, the plaintiff's claims rely entirely on subjective interpretations of routine medical decisions without concrete evidence of discrimination or policy violations. Statistical variations in treatment approaches represent normal medical judgment rather than discriminatory patterns. He continued for 15 minutes, reiterating arguments from previous hearings about the insufficiency of Eleanor's evidence and her failure to establish the elements necessary for a whistleblower claim under state law. In conclusion, Your Honor, the plaintiff has failed to present evidence that meets the threshold requirements for these claims to proceed. We respectfully request dismissal with prejudice. Harrison nodded approvingly throughout Patterson's presentation, his preference obvious to everyone in the courtroom. Thank you, Mr. Patterson. Ms. Chen, I assume you have some response, though, as I indicated previously, unless you can provide precedent supporting your position that statistical evidence alone can establish a whistleblower claim. I'm inclined to grant the motion. Chen rose with calm determination, placing a binder on the lectern. Thank you, Your Honor. Before addressing the specifics of the motion, I'd like to bring the Court's attention to a controlling precedent that directly addresses the sufficiency of statistical evidence in whistleblower claims involving healthcare institutions. Harrison raised an eyebrow, clearly skeptical. Proceed, though, I doubt it will change the outcome. Chen methodically introduced Reynolds v. Westfield Medical Center, explaining that the case involved remarkably similar circumstances, a nurse reporting statistical patterns in patient care, facing retaliation, and presenting evidence of institutional policy violations. As she began quoting from the judicial opinion, Harrison's expression shifted from mild disinterest to growing alarm, his posture stiffening as he recognized his own words being read back to him. Statistical evidence showing consistent patterns of disparate treatment, even without smoking gun proof of intentional discrimination, creates sufficient factual questions to survive summary dismissal and proceed to trial. Chen quoted directly from Harrison's opinion. The court further stated that whistleblowers who document systematic patterns through statistical analysis perform a vital function in healthcare settings where vulnerable patients may be unable to advocate for themselves. The hospital's legal team exchanged confused glances, hastily searching through materials for information on the case being cited as Marcus watched their growing discomfort with quiet satisfaction. Patterson whispered urgently to his associates, clearly unprepared for this line of argument. Harrison attempted to interrupt Chen's presentation, his face flushing slightly. Counselor, that case had substantially different facts and circumstances that warranted special consideration. Chen respectfully but firmly continued, producing side-by-side comparisons of the evidence presented in Reynolds versus Eleanor's documentation. With all due respect, Your Honor, the factual parallels are remarkable. Both cases involve nurses reporting statistical patterns in patient care, both present methodical documentation of these patterns, and both faced retaliation after making their reports. The primary distinction appears to be that Miss Reynolds' statistical evidence involved patient safety protocols, while Miss Johnson's involves racial disparities in pain management. As Chen proceeded through her carefully structured argument, Marcus quietly passed her a note, highlighting a key point she had overlooked. Harrison noticed the exchange, his irritation visibly mounting. "Miss Chen, is your client's child helping you argue this case?" he demanded, interrupting her mid-sentence. Chen hesitated clearly, trying to protect Marcus from Harrison's scrutiny. "Your Honor, my client's son has been assisting with document organization." Before she could finish, Marcus stood up despite Chen's warning gesture. "Your Honor, I apologize for the interruption, but there's a critical detail in your Reynolds opinion that directly addresses your concern about distinguishing these cases." The courtroom fell into stunned silence at the sound of this child's voice, confidently addressing the court spectators, exchanging astonished glances, while court staff watched with wide eyes few had ever witnessed a child speak directly to a judge during proceedings, particularly one as notoriously intimidating as Harrison. Harrison's expression darkened with patronizing derision. "Young man, this is not a place for children to play lawyer. Please sit down and allow the actual attorneys to handle these proceedings." Marcus remained standing, his posture respectful but his voice unwavering. "I'm not playing, Your Honor." On page 17 of your Reynolds opinion, you specifically stated that the similarity of statistical patterns alone can establish sufficient grounds for a whistleblower claim to proceed to trial, particularly in healthcare settings, where documentation of disparities serves the public interest regardless of whether intentional discrimination can be proven. Harrison's face flushed deeper as he recognized his own words quoted with perfect accuracy by a 10-year-old child, while murmurs spread through the courtroom at this extraordinary confrontation. Attempting to reassert control, Harrison directed a series of technical legal questions at Marcus, clearly intending to expose his lack of formal training and embarrass him into silence. "Since you seem to consider yourself learned in the law, perhaps you can explain the standard of review for summary judgment motions and how it applies in whistleblower contexts." To Harrison's visible shock, Marcus responded with, "Precision. The standard is whether, viewing the evidence in the light most favorable to the non-moving party, there exists any genuine issue of material fact that would allow a reasonable jury to find for the non-moving party." In whistleblower contexts, this court has previously held that documented patterns of institutional behavior create precisely such factual questions for jury determination rather than judicial dismissal. The gallery's murmurs grew louder as Marcus calmly addressed each increasingly complex question with accurate, well-reasoned responses, citing specific rules and cases with a facility that stunned even the experienced attorneys present. Hospital attorneys frantically conferred among themselves, recognizing the strategic disaster unfolding as Harrison's own precedent was being used against him by a child who seemingly possessed comprehensive knowledge of his judicial record. Harrison's attempt to call an unscheduled recess to regroup was met with Marcus's polite but firm objection. "Your Honor, Procedural Rule 59B requires that you rule on the motion before you before calling an unscheduled recess, unless there are extraordinary circumstances that you must articulate for the record." The gallery's reaction was immediate. Several attorneys in the audience visibly reacted with astonishment at hearing a child correctly cite procedural rules that even some practicing lawyers might not recall with such precision. Chen seized the opportunity created by Marcus's intervention, formally requesting that the motion to dismiss be denied based on the clear precedent established in Reynolds, which Harrison himself had authored. Given the court's previous recognition that statistical evidence alone can establish sufficient grounds for whistleblower claims to proceed, and the substantial statistical evidence presented by Ms. Cried, Brably Gay to Johnson, we respectfully request that the motion to dismiss be denied, and this matter proceed to discovery. Harrison found himself trapped in a predicament of his own making. Either follow his own precedent and allow Eleanor's case to proceed, or contradict his Reynolds ruling and create obvious grounds for appeal based on inconsistent application of legal principles. His internal struggle played across his features, as he realized he had no legitimate way to distinguish the cases without exposing his bias. Patterson requested a brief conference with the judge, likely hoping to find a procedural escape route from the corner into which they had been backed. Your Honor, given this unexpected citation of precedent, we request a brief recess to confer with our clients. Harrison reluctantly denied the request, acutely aware of the scrutiny now focused on him from the packed gallery, which included several attorneys who would certainly report any procedural irregularities to the wider legal community. Based on the precedent, cited, Harrison finally stated with obvious reluctance, the motion to dismiss is denied. The simple statement represented a monumental victory wrested through Marcus's extraordinary research and Chen's skilled presentation. Harrison wasn't finished, however, adding an unexpected twist. Furthermore, I am ordering the parties to mediation to be completed within 30 days. This case involves significant public interest concerns that might be more expeditiously resolved through mediation rather than protracted litigation. Eleanor embraced Marcus tearfully, as they realized they had survived the dismissal attempt, their case now guaranteed to either proceed to trial or reach settlement, either outcome representing validation of her whistleblower claims and a 70 path to potential reinstatement. The hospital attorneys gathered their materials with stunned expressions, clearly unprepared for this dramatic reversal of what they had assumed would be a routine dismissal. As spectators and attorneys filed out of the courtroom, many stopped to congratulate Chen or look with new respect and curiosity at the remarkable child who had effectively outmaneuvered a Harvard-educated federal judge using the judge's own words. Harrison issued a stern warning as he prepared to leave the bench. Young man, knowledge without experience can be dangerous. Remember that. After the judge exited, Marcus responded quietly, audible only to those nearest him. So can power without accountability, Your Honor. The confrontation that had begun with Harrison mockingly calling Marcus the little lawyer had concluded with the judge forced to acknowledge through gritted teeth the legal principle that would allow Eleanor's case to proceed, a principle he himself had established but never expected to be turned against him, certainly not by a 10-year-old black child he had dismissed as irrelevant to the proceedings. As they gathered their materials to leave, Marcus's expression revealed not triumph but quiet satisfaction that the system, however, reluctantly, had been forced to work as it should, providing equal protection under law regardless of power, privilege, or prejudice. The law offices of Garcia Wong and Associates occupied the 15th floor of Riverside's most prestigious downtown building, offering panoramic views of the city skyline through floor-to-ceiling windows, a deliberately prestigious Riverside's impressive setting designed to remind visitors of the firm's status and influence. Eleanor and Marcus arrived 30 minutes early for the court-ordered mediation, dressed in their best clothes, Marcus carrying a leather portfolio containing key documents he had organized for Attorney Chen. Their preparation for this critical negotiation had been intensive, with Marcus helping Eleanor understand the mediation process, potential outcomes, and strategic considerations. Remember, Mom, mediation isn't like court, he had explained, while role-playing various scenarios the previous evening. There's no judge making rulings, just a neutral mediator helping both sides find common ground. Stay calm, no matter what they say, and never accept the first offer, it's always a lowball. The strategic question of whether Marcus should attend the mediation had prompted lengthy discussion between Eleanor and Chen. Normally I'd advise against having children present, Chen had cautioned during their preparation meeting. However, Marcus understands this case better than anyone, and after his performance in court, the hospital knows his capabilities. His presence might actually strengthen our position. Eleanor had been adamant Marcus deserves to be there. He's the reason we've made it this far, and I want him to see this through. As they were escorted to the conference room, Marcus whispered encouragement to his mother, squeezing her hand reassuringly while maintaining the serious expression that had become his standard in legal settings. The hospital's representatives were already seated when they entered. CEO James Peterson, a silver-haired man with an expensive suit and practiced smile, Dr. William Griffith, looking considerably less comfortable, and 3 attorneys from the Henderson firm, including James Patterson. Their barely concealed surprise at seeing Marcus with legal notepads and binders suggested they had hoped the little lawyer would be excluded from these proceedings. The mediator, retired Judge Evelyn Montgomery, a distinguished black woman in her 60s, with a reputation for fairness and thoroughness, greeted them warmly. Good morning, everyone. I'm Judge Montgomery, and I'll be facilitating our discussion today. She specifically acknowledged Marcus with a kind smile. I understand you have a special interest in the proceedings, young man. I've heard quite a bit about your contributions to this case. Marcus nodded respectfully. Thank you, Your Honor. I'm here to support my mother and assist Attorney Chen with document organization. The mediation began with opening statements from both sides establishing their positions. Patterson presented the hospital's perspective, first characterizing Eleanor's termination as a legitimate response to disruptive behavior and unsupported allegations that damaged hospital morale. When Chen's turn came, she outlined Eleanor's whistleblower claims and the retaliatory nature of her termination, emphasizing the statistical evidence of racial disparities in pain management that had prompted Eleanor's original report. Eleanor then provided her personal testimony, maintaining remarkable composure as she described discovering the treatment disparities, her attempts to address them through proper channels, and the retaliatory actions that followed her. Report. I took an oath to provide equal care to all patients, she concluded. Reporting these disparities wasn't just my professional obligation, it was my moral responsibility. The hospital attorneys attempted to shake her testimony through aggressive questioning, suggesting alternate explanations for the statistical patterns and implying that Eleanor had been looking for problems due to her personal sensitivity about racial issues. Throughout this challenging exchange, Marcus passed occasional notes to Chen, with counterpoints to their arguments, his legal pad filled with observations about inconsistencies in the hospital representative's statements. Following the joint session, Montgomery separated the parties for caucus meetings, shuttling between rooms to convey offers and facilitate negotiation. During one of these separate sessions, Patterson visited their caucus room ostensibly to discuss settlement parameters, but clearly attempting to intimidate them with the hospital's resources. Even with your clever precedent maneuver before Judge Harrison, you're facing years of litigation against a wealthy opponent with virtually unlimited resources for appeals. He warned his tone, suggesting he was doing them a favor by pointing this out. The hospital is prepared to offer 6 weeks severance and a neutral reference, which is quite generous considering the circumstances. Before Chen could respond, Marcus looked up from his notes. Actually, we've prepared a timeline analysis showing the average discrimination case duration in this circuit. With your resources and our evidence, we estimate only 7 months to trial, with the hospital's projected legal costs exceeding $2 million before a verdict is reached. Patterson stared in stunned silence at this child's sophisticated understanding of litigation economics. Additionally, Marcus' continued preliminary analysis of patient records already in evidence indicates the disparities extend beyond pain management to other treatment protocols, which would significantly expand discovery if litigation proceeds. Chen built on Marcus's foundation. Mr. Patterson, we appreciate the hospital's initial offer, but as Marcus correctly points out, we're prepared to pursue this to trial if necessary. Miss Johnson's documentation is extremely thorough, and Judge Harrison has already acknowledged its sufficiency to proceed past dismissal. As Patterson returned to the hospital's caucus room, Marcus whispered to Chen, "They're more afraid of discovery than damages. Each round of document production would expose more evidence of systematic discrimination." Chen nodded, impressed by his strategic insight. "You're absolutely right. Let's emphasize the discovery process in our next joint session." When the parties reconvened, Chen skillfully incorporated Marcus's observation. "We're particularly interested in proceeding to the documentation phase, where all patient records from the past 5 years will be subject to examination, along with internal communications regarding treatment protocols." The CEO's visible discomfort at this prospect confirmed Marcus's assessment of their primary concern as Peterson whispered urgently to his attorneys. The hospital's offers improved steadily throughout the day, first offering reinstatement to a different position, then adding 3 months back pay, gradually increasing both the financial and policy components as the mediation progressed. Marcus's suggestion to prioritize structural remedies beyond monetary compensation proved particularly effective. The hospital needs to establish a patient care oversight committee with diverse representation, he advised Chen during a private conversation. Without systemic changes, the same problems will continue, even if Mom gets her job back. When Chen presented this proposal, the hospital representatives initially balked until Marcus mentioned the potential media interest in discriminatory healthcare practices. Transparency either happens voluntarily through settlement or involuntarily through trial and public record, he noted with the matter-of-fact delivery that had become his trademark. The breakthrough came 12 hours into the negotiation, when CEO Peterson finally acknowledged the seriousness of the allegations after reviewing the statistical evidence in detail. "I was not aware of the extent of these disparities," he admitted, his earlier dismissive attitude replaced by genuine concern. Regardless of whether they resulted from intentional discrimination or unconscious bias, they're unacceptable in our institution. The hospital's significantly improved offer represented a comprehensive resolution, full reinstatement to Eleanor's previous position with back pay and benefits, creation of a patient care oversight committee with Eleanor as a founding member, implementation of mandatory bias training for all medical staff, and establishment of ongoing monitoring protocols to identify and address treatment disparities. Eleanor expressed mixed feelings about returning to an environment where she had faced such hostility. With these policy changes, it won't be the same environment, Marcus reassured her quietly. You'll be going back with institutional validation of your concerns and structural protection against retaliation. The final negotiations focused on specific terms of the settlement agreement, with Marcus showing remarkable attention to detail as he caught several attempts to weaken the oversight provisions through vague language or limited scope. This clause should specify quarterly review of treatment outcomes across demographic categories rather than the annual review they've proposed. He noted to Chen, who incorporated his suggestion into the revised language. Judge Montgomery observed Marcus with growing admiration throughout the proceedings. "You have a remarkable future in law, young man," she commented during a break. "Your analytical skills and strategic thinking are extraordinary." The signing ceremony took place shortly before midnight, with Marcus watching proudly as his mother signed the agreement that vindicated her professional integrity and established mechanisms to address the very disparities she had risked her career to expose. The hospital CEO shook Eleanor's hand with grudging respect. "We'll expect you back on Monday, Miss Johnson. There's significant work to be done implementing these changes." As they drove home in the early morning hours, exhausted but victorious, Eleanor and Marcus celebrated quietly in the car, both processing the magnitude of what they had accomplished against overwhelming odds. "I told you they couldn't fire you for telling the truth." Mom Marcus said simply the statement, encapsulating both his childlike faith in justice and his sophisticated understanding of the legal principles that had made that justice possible. Neither could have anticipated how their victory would transform not just their own lives, but the healthcare landscape of their entire community, changes that would unfold in the months ahead as Eleanor returned to Clearwater Memorial, now empowered to address the very discriminatory practices she had been fired for exposing. 6 months after the settlement agreement, Clearwater Memorial Hospital had undergone remarkable changes that extended far beyond Eleanor's personal vindication. Her return to work had begun with a certain awkwardness, as former colleagues adjusted to her new position as Director of Patient Care Quality, a role created as part of the settlement to address systemic disparities in healthcare delivery. Her office's strategic location, adjacent to the administration suite, formerly an exclusive domain of white male executives, symbolized the institutional transformation underway, placing issues of equitable care literally and, figuratively, at the center of hospital operations. The Patient Care Oversight Committee, with Eleanor as a key member alongside diverse representatives from medical staff administration and community organizations, met weekly to review treatment patterns and address disparities. Conspicuously displayed throughout the hospital were data visualization charts, tracking equal treatment metrics by department, the public transparency, creating both accountability and measurable improvement as staff became aware that their treatment decisions were being monitored for bias. Dr. Sofia Rodriguez, who had supported Eleanor's initial report, had been promoted to the newly created position of Chief of Diversity and Inclusion, working closely with Eleanor to implement comprehensive changes throughout the institution. Following Eleanor's successful challenge, several other nurses and medical staff came forward with their own experiences of discrimination, creating a cascade effect that accelerated institutional reform. "Your courage made it possible for us to speak up too," a Filipino nurse told Eleanor during a committee meeting. "We saw what happened to you and thought our careers would be destroyed if we reported what we experienced. But now we know the system can change." The most dramatic personnel change had been Dr. Griffith's resignation 2 months after Eleanor's return, reportedly after board members questioned his handling of her initial report and subsequent termination. His replacement, Dr. Maya Patel, brought a progressive approach to patient care equity that aligned with the institutional reforms now underway. Eleanor's professional stature had grown beyond Clearwater Memorial as she received invitations to speak at nursing conferences about identifying and addressing care disparities, sharing the statistical methodology she had developed to Comperson's Staventu. Document treatment patterns. "The data doesn't lie" became her signature phrase in these presentations. When we measure care outcomes objectively across demographic groups, we create the foundation for equitable health care. Her relationships with those who had supported her termination remained professionally cordial but distant, the strained interactions a small price to pay for the meaningful changes she witnessed daily in patient care. Particularly satisfying was observing a workshop where the same nurses who had ostracized her received training on implicit bias in pain assessment training that resulted directly from her documentation of disparate treatment patterns. Perhaps the most unexpected development following the case was Judge Harrison's subtle shift in handling discrimination claims in his courtroom. Legal observers noted his more careful consideration of statistical evidence and greater willingness to allow such cases to proceed to trial rather than dismissing them at early stages. Harrison's judicial approach has evolved noticeably since the Johnson case, commented a legal columnist in the Riverside Law Journal. Whether through genuine reflection or concern about appellate review, his rulings show greater consistency in applying evidentiary standards across plaintiff demographics. Most surprising was Harrison's grudging recommendation of Marcus for the prestigious Young Legal Scholars Program at Riverside University Law School, a summer enrichment opportunity typically reserved for high school students, but occasionally open to exceptionally qualified younger applicants. Despite his youth, Marcus Johnson demonstrates unusual aptitude for legal reasoning, Harrison wrote in his uncharacteristically generous recommendation. His analysis of case law and procedural rules indicates potential that deserves cultivation in a structured academic environment. Marcus's life had transformed alongside his mother's, his extraordinary legal abilities now receiving formal recognition and development. His middle school principal, recognizing the futility of constraining his intellect within standard curriculum, had created an independent study program, allowing him to pursue advanced legal education while maintaining age-appropriate social interactions with peers. The special arrangement permitting him to observe court proceedings for educational credit had expanded his practical understanding of legal processes beyond theoretical knowledge. Miss Turner continued mentoring his legal education, now joined by several attorneys, impressed by his performance in the Clearwater case, including a constitutional law professor who corresponded regularly with Marcus about complex legal theories. Perhaps most meaningful to Marcus was the small legal clinic he and several classmates established to help students navigate school disciplinary procedures, applying his knowledge to protect other children from unfair treatment. "Everyone deserves advocacy when facing powerful institutions," he explained, when interviewed for the school newspaper about the initiative. His invitation to participate in a summer program at the state Supreme Court represented extraordinary recognition of his capabilities, with several college law professors beginning correspondence with him about legal theories after hearing the 7 of his role in the Clearwater case. The Johnson family's improved financial situation following the settlement had allowed them to move to a better apartment closer to Eleanor's work and Marcus's school, reducing their commuting time and creating more opportunities for the quality time together that both had missed during the difficult months of litigation. Their decision to establish a small scholarship for minority students interested in healthcare law using a portion of Eleanor's back pay settlement reflected their commitment to creating pathways for others to address systemic inequities. "We want to help others become the advocates and change makers our community needs," Eleanor explained at the scholarship announcement. Among the most unexpected communications they received was a letter from Richard Harrison, the hospital's former board chairman, and Judge Harrison's brother, acknowledging the positive changes resulting from Eleanor's case. While I initially viewed your claims as disruptive to our institution, he wrote the improvements in patient care metrics over the past 6 months speak for themselves. Your persistence in addressing these disparities has benefited our entire community. Eleanor's influence extended to personnel practices as she advocated for and mentored other minority nurses for leadership positions, gradually diversifying a management structure that had previously excluded people of color from decision-making roles. The hospital's recognition by the National Healthcare Equity Alliance as a model institution for diversity initiatives validated these efforts, with Clearwater Memorial becoming a case study for other hospitals seeking to address similar disparities. A follow-up statistical analysis conducted by an independent healthcare consultant confirmed the success of these initiatives, showing equalized treatment patterns across racial groups in pain management and other critical care areas. Tangible evidence that institutional discrimination could be successfully addressed through structured interventions and consistent monitoring. Marcus's first formal legal publication in the Young Jurist Review, titled "Consistency in Judicial Precedent: The Foundation of Equitable Justice," received widespread attention in legal education circles, with a copy anonymously delivered to Judge Harrison's chambers, a subtle reminder of the principles that had formed the foundation of their case. The special ceremony where Eleanor received the Riverside Community Leadership Award provided an opportunity for public recognition of both mother and son's contributions to healthcare equity. Marcus's proud introduction of his mother captured the essence of their journey. "She taught me that courage and truth matter more than power and position. When systems fail to deliver justice, ordinary people with extraordinary determination can force them to work as they should." During a weekend visit to David Johnson's grave, Eleanor and Marcus shared the story of their journey since his passing, the achievements neither could have imagined during the darkest days following Eleanor's termination. "I think Dad guided us," Marcus said, quietly arranging fresh flowers beside the headstone. "All those legal books he left, all those bedtime stories about justice, he gave us the tools we needed without knowing we'd need them." Eleanor nodded, watching her remarkable son with a mixture of pride and wonder at how adversity had revealed his extraordinary gifts. "Your father always said you had a special mind. He would be amazed, but not surprised by what you've accomplished." Marcus's growing interest in becoming a civil rights attorney had solidified through his experience with the Clearwater case, his natural legal aptitude now directed toward a specific purpose. "The system only works when someone makes it work," he observed with the clear-eyed wisdom that continually surprised those who encountered him. "Laws are just words until someone enforces them." The invitation for Eleanor to join Clearwater Memorial's board of directors represented the ultimate institutional acknowledgement of her value and vindication of her whistleblower actions. "Your perspective is essential as we continue rebuilding trust with all the communities we serve," the nomination letter stated. "Your courage in addressing discriminatory practices has made our institution stronger and more equitable." Among the most meaningful outcomes was a letter Eleanor received from the family of a Black patient whose pain management had improved significantly under the new treatment protocols. "For years, my father suffered unnecessarily because doctors didn't take his pain seriously," the letter stated. "Thanks to the changes you fought for, he received appropriate care during his recent hospitalization. Your courage made a difference for our family." Marcus's legal advocacy had expanded beyond his mother's case as he began helping another family facing workplace discrimination, applying the knowledge and strategies he had developed through their own battle. His careful documentation of the parallels between cases and identification of applicable precedents demonstrated his growing sophistication in navigating complex legal terrain. The final scene of their transformation played out in Judge Harrison's courtroom, where Marcus sat observing proceedings in a discrimination case as part of his independent study program. Harrison noticed him in the gallery during a recess, their eyes meeting briefly across the courtroom. The judge gave a small, reluctant nod of acknowledgement, a minor gesture but significant recognition of the child who had forced him to confront his own judicial inconsistency. Marcus returned the nod with a quiet smile, understanding that their confrontation had changed more than just his mother's case. creating ripples through the legal system that would benefit countless others facing similar battles against institutional discrimination. His notebook lay open on his lap, a page titled Future Cases, containing a growing list of injustices he had identified through his courthouse observations and community connections, each representing another opportunity to ensure that the placed legal system delivered on its promise of equal justice under law. The last line in his notebook captured the philosophy that would guide his remarkable future. Justice begins with one person willing to stand up. Have you ever witnessed someone whose courage inspired systemic change in your community or workplace? Share your experience in the comments below. If Marcus and Eleanor's story of determination and brilliance in the face of discrimination inspired you, please hit that like button to help others discover this powerful narrative. Don't forget to subscribe to our channel for more stories of ordinary people using extraordinary talents to transform broken systems. And if you know someone fighting their own battle against injustice who might find strength in this story, please share this video with them. Sometimes knowing others have prevailed against overwhelming odds provides exactly the prover and encouragement needed to continue the fight. Thank you for joining us on this remarkable journey from a judge's mockery to a community's transformation. May it remind us all that justice often begins with the most unexpected advocates, and that even the youngest voices can speak powerful truths that change our world for the better. Marcus Johnson's story reminds us that true justice often requires unexpected champions. While society might dismiss a child's voice, Marcus demonstrated that knowledge and preparation can overcome even the most entrenched power structures. His extraordinary legal mind wasn't just about memorizing cases, it was about understanding how to use a biased system's own rules to create accountability. The most powerful lesson is how Marcus identified Judge Harrison's inconsistency and used it as leverage for justice, showing that even those who wield authority must eventually answer to principles larger than themselves. Eleanor's courage in reporting discrimination despite the personal cost demonstrates that institutional change often begins with individual sacrifice. Together they reveal how systems designed to protect privilege can be transformed when confronted with their own contradictions. Their story teaches us that justice isn't automatic. It requires advocates willing to document patterns, research precedents, and demand consistency. Perhaps most importantly, we see how discrimination thrives in shadows, but withers under systematic documentation and public scrutiny. The transformation at Clearwater Hospital proves that addressing bias isn't just about individual cases, but about creating systems that monitor, measure, and correct disparities over time. True justice requires both moral courage and strategic brilliance, qualities that sometimes come in the most unexpected packages. Have you ever witnessed someone standing up against injustice when everyone expected them to stay silent? Or perhaps you've been underestimated because of your age, race, or background, only to prove your critics wrong. Share your story in the comments below. If Marcus's legal brilliance and Eleanor's courage inspired you, please hit that like button to help others discover this powerful narrative of justice prevailing against overwhelming odds. Don't forget to subscribe to our channel for more stories of extraordinary individuals challenging broken systems and creating meaningful change in their communities. And if you know someone facing discrimination or battling powerful institutions who might draw strength from Marcus and Eleanor's journey, please share this video with them. Sometimes knowing that others have succeeded against similar obstacles provides exactly the hope and strategic insights needed to continue fighting. Thank you for joining us for this remarkable story of an unexpected legal prodigy who turned a judge's mockery into a catalyst for systemic change. May it remind us all that justice often comes from the most unexpected sources, and that with knowledge, preparation, and unwavering determination, even the youngest among us can transform their communities for the better.